This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you for joining us today. My name is Hayward Cho. I am the General Manager of ADR Services in Southern California. Today's webinar is titled Surviving Arbitration, presented by the Honorable Jacqueline A, the Honorable Joe Hilberman, and the Honorable Gerald Rosenberg.
Okay, is this morning or afternoon? I guess it's afternoon. Good afternoon. I get the privilege of introducing the first speaker, who's going to be Joe Hilberman. So Judge Joe Hilberman served in the LA Superior Court from 2002 through 2009 after 27 years in civil litigation. He's currently a full-time mediator, arbitrator, discovery rep with ADR Services throughout the state of California. He was recognized by the LA chapter of BOTA as Jurist of the Year in 2008 and by the LA Daily Journal as one of the 50 best neutrals in California. He's a frequent lecturer and writer on topics of mediation and litigation. Judge Hilberman has served as an adjunct professor at UCLA School of Law, Loyola Law School, and has been a guest lecturer at both the Pepperdine and Southwestern Schools of Law. He serves on the board of directors of UCLA School of Law Alumni Association as past president and the LA chapter of BOTA. And he can sing. And he also has a wicked sense of humor. Go, Joe.
Thank you, Judge Connor. The wicked sense of humor was pointed out to me by the Court of Appeal. Actually, they thought that my rulings were pretty funny. Thanks for coming. My topic for this afternoon is going to be a discussion about arbitration and disclosures, required disclosures in arbitration by the arbitrator, as well as talking about Zoom arbitrations. We'll start talking a little bit about the disclosure issues. There's some statutory issues that you should be aware of. The primary purpose of all of this is to ensure the neutrality of the arbitrator. The California Code of Civil Procedure 1281.9 addresses the duty to disclose, as do the California Rules of Court in Standard Number 7. Essentially, I think it's stuff that makes sense. I think most laws do tend to make sense. And if you understand the principle behind it, I think it becomes much easier. There are also grounds for disqualification, and the code under CCP 170.1 deals with some of those requirements that give rise to disqualification of a neutral. Some of the things that need to be disclosed, of course, would be the names of the parties and the counsel involved in the case, disclosure regarding any prior arbitrations that the neutral has had with those parties or counsel, any former attorney-client relationship that the neutral may have had. And I think significantly, and that's a classic word, the code makes reference to any significant personal or professional relationships with an attorney or the party. I find that one to be most important because, as we know, sometimes it is the appearance of impropriety which is more significant than whatever is actually going on. So I know I and my colleagues are very careful not to serve as neutral arbitrators in cases involving folks with whom we have a close or significant personal relationship as well. In my own practice, I'm happy to serve as a mediator in those cases because I'm not making a decision, I'm not ordering anybody to do anything. But there are several attorneys in town with whom I have a personal relationship, and I've chosen not to serve as an arbitrator in those cases because of that appearance or the potential appearance of impropriety. Some of the other issues that are set forth under Standard 7 in the Rules of Court, which are very similar to those addressed in the CCP, are the disclosures that are required when there's an offer of employment to the neutral. The neutral has the obligation to make the disclosures at the time that the potential case is offered to him or her, and has to do so, I believe, within 10 days of the offer. You have to talk about familial relationships, relationships with the lawyers, as I mentioned, if the arbitrator has ever served as an attorney for any of the parties, personal relationships with the party or lawyer, and others. And I would encourage you to take a look at Standard 7 in the code. We also have particular rules at ADR Services. In our services rule number 12 under arbitration rules at ADR, which are posted on the web, it's quite inclusive because it includes reference to any statutory responsibilities for disclosure and requires the arbitrator to disclose any circumstances likely to affect his or her impartiality or independence. I think it's really important that lawyers feel completely comfortable with the arbitration procedures and proceedings so that they will appreciate the neutrality of the arbitrator, who will then be making a binding, in most cases, a permanent and binding decision in their case. With that, I'd like to move on. I would encourage you to look at those code sections. Remember CCP 1281.9, Rules of Court Standard 7, disqualification under 170.1. And again, remember, it's the appearance or something that someone would reasonably believe would cause the arbitrator to be biased in favor of one side or the other. And it's the reasonableness standard, I think, that most arbitrators would embrace most strongly, because nobody wants to be criticized following a ruling for having been biased against or in favor of one or the other parties. So I encourage you to read those along with the ADR rules number 12 and incorporate that as you're looking for arbitrators. Remember, you'll be getting a declaration, a disclosure from the neutral regarding addressing, I should say, those standards and those factors. When you get that, be sure to take a look at it and respond to the organization for whom that arbitrators, or with whom that arbitrator is associated. I recently had a case in which we made full disclosure, and months later, after making some interim rulings, one of the parties said, well, wait a minute, you've had X number of cases with this other organization before, all of which had been disclosed. At that point, I made a decision to withdraw from the case because it creates a no-win situation about this. On one hand, if I were to say, no, I'm going to continue, and I ruled in favor of the party who was raising the objection, the party who lost would have said I was intimidated by that objection. If I ruled in favor of the party who was not objecting, the objecting party would say, see, I told you so. He's biased in favor of those guys. So I thought the reasonable thing to do to avoid that kind of a conflict was to withdraw, which I've done. So avoid those kinds of issues, particularly when, as in this case, people get deep into the problems, by taking a very serious and thoughtful look at the disclosures that you get in each case. I'd like to turn a little bit now to the question of Zoom arbitrations. All of you who are in attendance today are obviously well-versed at Zoom. I haven't had an in-person appearance in almost 2 years. Of course, it'll be 2 years in March. I concluded a 2-week arbitration in our San Francisco office, and I've never been back. It's worked well, and I would encourage you all to feel comfortable with Zoom, both in a setting of mediations, which I'm sure you're doing, as well as arbitrations, which has become more common to be in person. But still, all of my arbitrations personally have been by Zoom, including one that concluded just yesterday. So let me give you some tips on Zoom from my perspective. First of all, it's really critical to be familiar with Zoom as a platform and how to use it. Be sure you have good internet connectivity. I had an arbitration, a 2-week arbitration in a rather complex medical malpractice matter. The first week, the claimant's attorney attended from his office in Century City and was having lots of freezing problems and dropping problems, and it was a mess. So he did the only reasonable thing for the second week of the hearing and connected from his home in Aspen, Colorado, which I thought was very appropriate, and offered to move the entire proceeding to Aspen, Colorado, which was declined by counsel for some reason. So be sure to test the connectivity of your computer, the lighting, your sound, and we're talking both about the microphone and the speaker system. I use a built-in speaker on my computer. Most of the time it's fine. Sometimes I use little ear things that have built-in speakers and microphones, and those work well. But just be sure you test them. And Zoom has a pre-conference test that's available where you can test both the sound and the speaker, sound and the microphone before you join the meeting. Which brings me to joining the meeting. Be sure that you're familiar with the process of joining the meeting. I'm sure that all of you have participated in Zoom meetings and you're probably pretty good at it. I've had circumstances where the host isn't quite ready, and so you wait for a while, which brings up the issue of how to be the host. There are a number of online tutorials to how to best maximize the effectiveness of Zoom, and I would encourage you to use those. Be sure you have your client available for the arbitration, either in your office, perhaps and preferably with social distancing in a different office within your office spaces, or from their home. Teach them, give them some instruction on what to expect from Zoom. I know you'll be talking with them about what to expect from the arbitration itself, what the roles of the different parties are, who the witnesses will be, preparing them to testify and be cross-examined, and as well as the role of the neutral arbitrator. But also teach them about the use of Zoom and what they can expect. Be sure they put away all kinds of distracting things. I was telling my colleagues I recently did a mediation where the claimant kept looking aside. He was in his own home. His lawyer was in a different place. And I finally asked him, I said, what are you doing? And he said, well, I have 726 followers and they're telling me what to do. So I encouraged him to close his computer, listen to his attorney, and let's keep going. So be sure there are no distractions and no interruptions by cell phone or other computers. In instructing your client, be sure to tell them what to expect from the arbitrator as well, and that the arbitrator has the ability to move people in and out of rooms, that they'll have a separate and confidential conference room to speak with their lawyer during breaks, and be sure you're familiar with how that works. The screen sharing function is really, really critical in arbitration. I require in my cases that the parties provide the neutral as well as each other with a joint witness list, joint exhibit list, and an arbitration brief no fewer than 5 court days before the commencement of the arbitration. That way everybody has a hard copy of the documents to refer to. But in Zoom, particularly if we're using experts who reside outside of your local area and they're not going to be in the room with you, screen sharing becomes really critical. So be sure to learn the screen share function and be able to bring up documents for either your client or a witness to use, particularly an expert witness who may want to make reference to, for example, yesterday, property damage on a vehicle, or an X-ray or a CT scan. That way everybody can see the same document at the same time and will have a hard copy to refer to and make notes on while it's being referred to in the screen share. The witnesses, when you have witnesses, be sure they're familiar with the Zoom proceedings as well, particularly lay witnesses who may not have the experience or expertise in utilizing Zoom. I'm certain that all of you do at this point, almost 2 years into our pandemic use of Zoom. And all of the experts that I've heard in testimony have all been well-versed as well. But it's the lay witnesses who have to be coached as to how to utilize Zoom, how to deal with talking to a computer screen instead of a real person. And I think that, not that you're all not real people, but I think that those are a little bit foreign to many people, and we have to be able to ensure that they're comfortable with that. The last thing I want to come back to is something I mentioned before in terms of the timely producing of the exhibit list, the witness list, and the arbitration brief. As I mentioned, I require that the parties meet and confer and have one set of exhibits. We don't want to have, for example, plaintiff 17 is the same as defendant's 126, because then we move back and forth between those two. Everybody has to meet and confer, stipulate if they can to the foundation of documents, and then have them in one orderly document that sets forth only one time for each document. And the same is true with the witness list, and provide the arbitrator with an outline as to who will testify when and on what subjects. And then be sure to provide an arbitration brief to your opposing counsel as well as the arbitrator. And I do request that it be at least 5 days, 5 court days before the commencement of arbitration, because everybody wants to be as fully prepared as possible. Those are my thoughts about doing Zoom arbitrations from my perspective. I'm happy to have questions if we have time at the end, or you can simply email me at ADR Services, and I'm happy to respond. It's now my pleasure, and it's a privilege, to introduce a friend and colleague. I had the privilege of serving in the Santa Monica Courthouse with both Judge Connor and Judge Rosenberg. Judge Rosenberg was sworn in to practice law in 1975, although he looks much younger, and maintained his litigation practice until he was appointed by the judges of the Superior Court as a court commissioner in 1995. He served as a commissioner in both Beverly Hills and Santa Monica courthouses until he was elevated to a judgeship in the year 2000. Judge Rosenberg is well regarded as a learned and considerate jurist with an impeccable judicial temperament and thorough knowledge and application of the law. After initial assignments in criminal preliminary hearings and trials, civil trials, family law, and probate, Judge Rosenberg spent the majority of his career presiding over an unlimited jurisdiction civil court in the Santa Monica Courthouse. In addition, he served as assistant supervising judge and later supervising judge of the Los Angeles Superior Court in the West District, where he was my supervising judge and never once held me in contempt. In recognition of his judicial achievements, Judge Rosenberg was named the 2017 Trial Judge of the Year by the Los Angeles chapter of ABOTA, the American Board of Trial Advocates, and the 2011 Outstanding Judicial Officer by Southwestern Law School. In addition, and this is great fun, from 1982 through 1994, he served as the statistician for the Los Angeles Raiders. Los Angeles Raiders. He was responsible for preparing all game day statistics for distribution to the NFL, the Raiders, the visiting team, and the media. And he had the honor of serving as the official scorer for the 1987 and 1993 Super Bowls and the American Bowl in Barcelona, Spain. Judge Rosenberg.
Thank you, Joe. It's a great privilege for me to be working at ADR Services as a mediator, arbitrator, and special reference. In addition, I have worked with the members of this panel as colleagues, both on the Los Angeles Superior Court bench and now as colleagues here at ADR Services. Serving as an arbitrator is similar to the work I did as a judge presiding over non-jury trials. During my 24 years on the bench, I handled many court trials and found the process of receiving evidence in open court with the attorneys in front of me and the witnesses close by to be an ideal environment for the receipt of and the testing of evidence. Now, as an arbitrator, I want to have the same type of environment for the ultimate purpose of correctly receiving relevant evidence, hearing from the attorneys at each stage of the proceeding, and to be able to judge the credibility of those who will testify. I want to be able to reach a fair, just, and well-reasoned decision. When I sat down to collect my thoughts on the in-person arbitration process, I had those goals in mind, and my comments today are shared with you so that you understand what helps an arbitrator to reach a proper arbitration award. Some of the advantages of an in-person arbitration hearing, as opposed to one being conducted virtually, such as through the Zoom provider, or a hybrid proceeding, which is both in-person with some witnesses participating virtually, are as follows. First, I want to concentrate on exhibits, which are so important to the outcome of any arbitration. When the arbitration is in person, counsel provide me with copies of their exhibits, numbered and bound. They are easy to access. They're usually easy to read, and if the original is needed, then counsel can provide it. They can be put in front of a witness to help understand his or her testimony. Another important component of an arbitration is the testimony given by witnesses. Not only is the arbitrator taking information from those witnesses, but as I said earlier, the arbitrator is judging their credibility. Now, it's easier to judge credibility when you sit in the same room. The body language of a witness cannot always be seen via Zoom. A witness cannot use notes to testify unless they're needed to refresh his or her memory. However, what if the notes to the arbitrator, a witness while testifying via Zoom, is relying upon his or her notes? Imagine that I am a witness in an arbitration proceeding. Even though I may sound very convincing while testimony, what if in reality I am reading my testimony? Also, if a witness testifies remotely, is there someone else near the witness who is aiding him or her? If that aiding person is out of the Zoom box, then he or she cannot be detected. Whiteboards can be used with ease in person, allowing either the witness or counsel to put information in front of the arbitrator while the witness testifies. This can be very helpful in person, but very difficult or impossible using Zoom. The in-person arbitration creates a more solemn atmosphere for the proceeding. Often counsel or witnesses are less formal over Zoom. Now, I have a bit of a conflict when it comes to experts. My preference is to have an expert testify in person. His or her testimony can be critical to many cases, especially in a case like a medical malpractice claim. Another good example is a construction defect case where the testimony is needed to explain the defect, its extent, and the cost to remedy it. However, I realize that counsel are faced with a variety of issues when it comes to an expert. It can be difficult, it can be costly to transport and house out of state or out of area experts. And instead of having them wait around until we're ready for their testimony, it's much easier if we have them brought in promptly via Zoom. I will indicate that I am willing to work with counsel with respect to their experts, and certainly if those experts have provided reports or estimates and photographs to support their finding. And it may be fine to allow them to testify remotely. People often ask me, well, if we're going to do an in-person arbitration, what about health concerns created by the COVID pandemic? And I will tell you that we can overcome many of those issues. There are many large conference rooms at ADR Services. This allows us to space out the participants. Also, masks can be worn. We also have available large plastic barriers, and they can be placed between the participants to help. If too many people are attending, some of the participants can be put into a separate nearby room with a Zoom link so that they can follow the arbitration and then be brought into the main room when their testimony is needed. There is better control over an in-person proceeding, while Zoom often presents issues. Zoom is dependent upon a good, stable Wi-Fi connection. If the connection becomes unstable, then the testimony of witnesses often becomes interrupted. A Zoom conference also can stop, and all the participants are left with having to log back in. Poor lighting can create a problem and make it difficult to see the witnesses and the attorneys. There often can be sound issues. How many times have you been on a Zoom conference when gardeners are at work in the area, dogs are barking, maybe spouses or children are reaching out to you? Exhibits can be difficult to locate. Now, in jury trials or bench trials, a judge is required to apply the California rules of evidence. I want to tell you that something that occurred recently. I lectured to a group of students at the USC School of Law. And as part of my presentation, I had asked the students about their experience with evidence. Now, I was speaking to second year and third year students. And when I asked them about evidence, they said to me, well, it's not required. But then they were very happy to hear that in arbitrations, the rules of evidence are often relaxed. In many of my arbitrations, counsel often argue over admissible evidence. So to help us with this issue, I'm going to refer to some sections of the arbitration rules that are contained within ADR Services rules and the CCP. With respect to Rule 33 of the ADR Services Rules of Arbitrations, the arbitrator shall conduct the hearings in accordance with these rules, and the arbitrator may vary these procedures if it is determined reasonable and appropriate to do so. The arbitrator shall determine the order of proof. The arbitrator shall, at his or her discretion, exercise all powers relating to the conduct of the arbitration hearing, which shall be conducted in a manner that will promote the efficient and expeditious resolution of the dispute. Strict conformity to the rules of evidence is not required, except that the arbitrator shall apply applicable law relating to privileges and work product. The arbitrator shall determine the admissibility, relevance, and materiality of the evidence offered and may exclude evidence deemed by the arbitrator to be cumulative or irrelevant. With the agreement of the parties or by order of the arbitrator, the presentation of evidence may proceed by means other than in-person appearance, including but not limited to video conferencing, internet communication, and telephonic conferences. The arbitrator may receive and consider the evidence of witnesses by declaration or affidavit. Now, though these rules provide that strict conformity to the rules of evidence is not required, personally, I'm reluctant to give much weight to testimony which has no foundation for its truthfulness or testimony based upon hearsay. And I believe that the laxity of some of these rules are really more helpful when dealing with documentary evidence. Also, I need to note that under the CCP, it states that the parties to the arbitration are entitled to be heard, to present evidence, and to cross-examine witnesses appearing at the hearing. But rules of evidence and rules of judicial procedure need not be observed. In California, one of the few ways an arbitration award can be overturned is for the arbitrator to refuse to hear evidence material to the controversy. So I think it's fair to say that most arbitrators will play it safe by hearing all relevant evidence, even if it is in the form of hearsay or declarations. Thus, all objections must usually go to the weight of the evidence rather than its admissibility. Now, from in-person arbitrations, we're going to hear from Judge Connor about hybrid arbitrations. Following a decade as a prosecutor in the Los Angeles District Attorney's Office, after obtaining her degrees from USC prior to her 1986 appointment to the bench in Los Angeles, Judge Jacqueline Connor has tried over 200 jury trials. As a trial lawyer with hundreds more on the bench in both criminal and civil cases. In her 25 years presiding in trial courts, she handled cases ranging from death penalties to construction defect to medical malpractice. She was recognized as a national expert on jury reform and has lectured widely and published numerous articles over the 45 years of being on the front lines of our justice system. Named Judge of the Year from multiple organizations and identified as a top mediator, she is excruciatingly aware of the costs and risks of litigation that have arisen with the availability of information on the internet, the changing demographics of our juries, and the unpredictable impact of COVID. She has been dedicated to resolving disputes out of court as a mediator, arbitrator for ADR Services since 2012, bringing an additional unique perspective from having been raised outside the United States with a fluency in Japanese. I present to you Judge Jacqueline Connor.
Konnichiwa, if we have any Japanese speakers out there. Thank you, Joe and Jerry. It's really a pleasure to be here, and it's nice to be on a panel with friends. We go back decades, I think. But it's interesting because we all have different experiences with this changing COVID. I know Judge Hilberman says that he hasn't had anything in person. I think I've been going in maybe once to twice a week now, either Century City or downtown, and depending on the needs of the attorneys. There are ways to protect yourself. There's ways to handle this, but there are some issues that do need to be addressed. Joe and Jerry both mentioned some of them. I'm going to reiterate them, but I'm going to be talking about hybrid arbitration. So I'm going to be dealing with the idea of what happens when you have to me, it's the best of both. It could also be the worst of both. But the idea that if you have an in-person arbitration, perhaps there may be a witness or two or many witnesses, sometimes even an attorney, if it turns out that the only way they can appear because of happenstance or whatever is through some kind of remote appearance. I also approach this is very practical. I approach this as a exercise, assuming the rare instance when the attorneys are mortal enemies. Parties are often mortal enemies, but why does this happen? Sometimes the attorneys are mortal enemies too, and they will not give an inch to the other side or take advantage, or one side feels like they're taking advantage. So I want to address some of the things that can go wrong with the use of remote witnesses in an arbitration setting, and presenting this in the form of a kind of a template for what you may want to discuss in advance, what you want to plan, how you not get in trouble, and how you not become disadvantaged by some of the glitches that happen. One of the first things, and this is something that Joe talked about already, we certainly need to make sure, and this is the attorney's responsibility, we need to make sure that the witness and the parties are all on the same platform. We have multiple platforms. There's WebEx, Blue Jeans, Zoom. I think all of our preference is Zoom, and it seems to be the most user-friendly, but there are others, and you sure want to find that out in advance. It's their responsibility to make sure the witness is comfortable with it, knows how to work it, knows how to turn it on, knows when to turn it on, make sure that the witness is able to communicate with the arbitrator or whoever's calling them that, oh, by the way, I can't hear anything, or I can't see anything, whatever it might be, just to make sure that they know what the practice is, that the volume is adequate, not only for us to hear them, but for them to hear us, that the visibility is clean and precise, that the background is not cluttered, or certainly we don't want a virtual background because people can hide. Like those whiteboards are really helpful, but we don't want them in a Zoom situation. Noise feedback, muting it when you get the feedback, that also has to be worked out in advance to enhance the presentability, I suppose, of that remote witness. And for the attorney who's calling the witness, obviously they think it's important enough. So that attorney has to make sure that it's done in a way that's the most effective. If you don't care if the arbitrator hears you, then why do you call the witness at all? So I approach it from the position that they want me to hear everything. Remote testimony should be in a private place. Believe it or not, there have been times when a remote witness opened up their laptop, and here they were sitting in an airport testifying between flights, or perhaps in a Starbucks. Not a good idea. In the course of presenting, there's also some planning that needs to go into disabling the chat features, not only to prevent perhaps inappropriate private chats, but perhaps there's a private chat that didn't know they weren't private and everybody is reading what may show up. So you want to disable that chat feature. Typically for me, I am the host and I will be letting people in, fixing stuff. It's a good idea to have a co-host available. ADR Services does provide an entire IT backup team, but there are some venues, if you're in arbitration, that may not have that available, and you may want to consider having something available, or at least having a co-host there. The problem with some of the glitches that happen if the arbitrator is the co-host or is the host is that it really distracts the arbitrator. And if I'm a practitioner, I want that arbitrator listening to everything I'm putting on. I don't care if they miss the other side, but I want them to hear mine. So it's a good idea to have the co-host pick up some of the problems that occur. The screen size is critical. If you have everybody's in-house except for perhaps one or two, maybe many remote witnesses, it's important that the screen that they appear on is a large screen, that we're not all looking at, either a laptop or even a desktop or somebody's computer. Should be looking at the same thing. If there's a glitch, if there's a problem with sound, I would imagine, and I'm sure that parties are concerned that everybody's in the same boat. If we know that someone has lost sound, everybody knows that we can deal with it. But to disadvantage one side or the other, perhaps without them knowing about it, can create a problem later on. So I think it's critical that the screen size for that remote witness is a large one. Now, with respect to that screen size, this is something that I'm giving advice on because I don't always follow it. But that screen should be close to the arbitrator. Typically what happens, we might have the arbitration going on in a large room. I've got a long table, claimants on one side, respondents on the other side, and the screen's way down at the other end. The problem is if something happens that deflects the noise, maybe there's a leaf blower or the garbage truck goes by and people forgot to include that. You want to make sure that the arbitrator hears everything. The arbitrator may not say, oh, I missed that word, or I missed that point. We as arbitrators don't always know what you're going to end up focusing on. We have an idea, but there may be something in that missed statement that you as a practitioner don't even know was missed. So one of the things I think that we can do to resolve that is when the remote witness is testifying, the arbitrator needs to be closest to the screen so that they don't miss anything. If there's an issue with respect to interpreters or videographers, there has to be some planning as to whether they'll be in the same room. Are they going to be in the same remote site? Do they understand about the technology? I also think it's very helpful to plan ahead of time when the remote witness is going to testify. 1 o'clock Friday, 10 o'clock Thursday morning, and stick to it. That allows the witness to check in 30 minutes before, I think at minimum of 30 minutes before. You know how technology happens. You can practice before it happens. You got everything lined up. The video's there. All you have to do is boop. And when you do the boop, it doesn't work. It's not working. How many times does that happen to us? All the time. So they need to be assigned, I think. If it means a little bit more flexibility with the witnesses who are present, I think we can have that flexibility. If the witnesses who are present are perhaps on a very expensive time clock, you want to keep that in mind when you set the time for the remote witness to appear. And I think it's important you stick with the time. Screen shares are terrific. It's an interesting technological advance that is very helpful, but there are some issues with it that you need to not forget about. If everyone's in the same room and it's all in person and they're looking at the same screen, that's one thing. But if you have a remote witness who's looking at the shared screen, you know there are little tiny postage stamp up at the side. We can't see them anymore. If you want your arbitrator to be able to see your witness, and there may be reasons why you don't want them necessarily to see your witness, but assuming you want them to, it's important that you deal with the idea of a shared screen or double screen. Have a second screen up there for the exhibits and a full screen so that the person can be seen. Also, I think in terms of logistics, one of the things the council has to do, and perhaps the arbitrator or the administrator needs to do, is to make sure that there is a breakout room to allow the person calling that witness to be able to consult with the remote witness without having to make it too obvious, or without having to make it seem like something has gone wrong. But there should be a breakout room for that remote witness. If there's multiple parties, perhaps appearing remotely or even in person, you need to pay attention to the size of the room. I think Jerry talked a little bit about the size of the room and needing a little social distancing. One of the options, as he mentions, is to have some of the witnesses perhaps in another room. So you need to make sure the screens are set up in the other room and that they can see and they can hear, and there's some communication going back and forth if something goes wrong. There's an issue with the arbitrator being the host when there may be some inappropriate, or what may appear to be inappropriate, ex-parte communications when they're bringing people in or logging them in, admitting them into the waiting room or from the waiting room. The best thing to do is, if there's more than one, is to have them all come in at the same time before they're put into the breakout rooms. But that's another reason why it's probably good to have a co-host or someone else who's managing this. You also want to control who's watching. You know, we have excluding orders for witnesses not to be there to listen to what the person in front of them has to say. On the other hand, sometimes we want to have them present when, for example, and I think this is one of the best uses of hybrid arbitration, is to have the opposing expert listen to the first expert. So they're actually talking about the same thing. So they're talking about apples and apples instead of apples and oranges. If the opposing experts are going to be watching, they can be in another room. The screen should be there. There should be some checking to see that they actually have access and that their visual and the audio is appropriate. Okay, what if we have conflicting time zones and conflicting laws? I have had this happen where one of the witnesses was testifying from Monaco. That was pretty cool. Or Singapore. That was even more cool. Or New York. The time difference is one where I've had witnesses say, you know, I just hate testifying when they're in California because they forget that it's 7 o'clock for me. Maybe it's getting close to happy hour, and that's not such a happy thing. But you want to keep track. Perhaps the person had to fly in and they're on jet lag, and the timing is critical. So in terms of setting the specific time when that remote witness is going to appear, it's important to set it up so that we can accommodate some of the issues for time zones and have that kind of be on front radar to keep that from becoming a problem. If we have different jurisdictions, there may be different laws that apply. It may, in a different jurisdiction, a different state, there may be a different requirement for the type of oath that actually binds somebody. There may be a difference in the law about who administers the oath. There should be, or sometimes are different laws concerning the legal power of the arbitrator to impose consequences when something goes wrong. What if a remote witness doesn't show up? It isn't always like it's our paid experts who are going to be calling as remote witnesses. Perhaps it's someone in another state who is an ex-employee who really doesn't want to be there. Maybe they walk out. Maybe they don't show up. What are the rules in that other jurisdiction for the power of the arbitrator to do something about it? It's different than California oftentimes, and it's something we need to be aware of. There certainly has to be planning for delay. If somebody doesn't show up, you got to have your backup witnesses so you don't lose time. Typically, we have, you set the number of days for the arbitration, 2 days, 3 days, people locking their calendars. If the attorneys get along, most of this is not a problem and you can probably extend it. But on the other hand, now you have calendar problems so that the extension, the extra witness you want to come back for another half day could be a month away. And by that time, I can tell you with we arbitrators and we neutrals, we're doing other stuff and the nuances get a little bit lost. So it's pretty critical that you keep within the time frame as much as possible. Mock practice sessions are very, very helpful. The question is who administers it, who pays for it. Maybe the attorneys can provide or agree to somebody and split the cost. ADR Services does provide these mock practices, and it does ensure that the equipment is all known and familiar to the witnesses. Everybody can see and hear. I did have a situation, kind of the ideal, where the opposing expert was in the other room watching. It sounded ideal until he walked in to do his testimony. And he said, I couldn't hear anything. I don't think the attorney who was arranging this thought that was such a great idea, but it was almost like, I'm good enough. I don't need to hear what the other side has to say. I've got the truth and they don't anyway, so whatever. But it does help the arbitrator to have the experts addressing the same issues and responding to the same questions. And if they're in the other room, you want to perhaps check every once in a while to make sure that they're hearing it, that they have access. This can be the attorney checking, it could be the IT manager. If the arbitrator is the sole host, again, there's a real problem with distractions for dealing with some of these things and not paying attention to the witness. If you want the arbitrator to pay attention to the witness, you want to make sure that the arbitrator doesn't have to deal with those issues. Confidentiality is an issue that I have been made aware of, and that initially I'm talking about the exhibits. If we have a hard copy, always my preference. I'd sure prefer to have a hard copy because I like to look at the pages. Sometimes when the digital copy is up on the screen, it's too small, then they expand it and the pixels are too large and now it's not very sharp. So you may want to keep that in mind as you take a look at that. But I think it's best to have the witness have a hard copy so that when the technology fails, which invariably it does in some fashion, we're all looking at the same thing, but understanding that there are times when the person doing the examining is going to want to point to a certain place or a picture or whatever it might be that they need it on a digital platform, that we have two screens again, so we don't have the witness up in the postage stamp in the corner. If the exhibit is one that is going to be, it's secret, they're going to spring it on the witness for impeachment or whatever. One of the ways it can be done is to provide it in a sealed envelope and have them open the envelope on screen. One of the thoughts was made to have colored tape so you can see them undoing the tape. Or if it's a digital exhibit, perhaps they can be provided with a password only when the object's necessary or when it's ready to be opened up. Witnesses need to be trained. They have to be familiar with the equipment. They need to understand about sharing the screen. They need to be told you cannot multitask. Well, is this one who's checking his followers, Joe, to see what's going on? It could be a lawyer who's not quite ethical, or it could be a client who doesn't have a clue. This person who was checking his followers didn't think there was anything wrong with it. I mean, to me, that's kind of a little generational collapse that we do have to be aware of. For some people, it's just not an issue. They need to know what they're supposed to be doing and how they're supposed to be doing it. They cannot multitask. Who do they call if there's a problem? How can we reach them if there's a problem? And here's something that I know happens all the time. It happens in real life, but it certainly happens, I think, even more when you have a remote witness. And that is a situation where an objection is made, but the witness can't hear it or doesn't understand what it means. And they keep talking, and sure enough, the one thing the attorney didn't want them to hear comes blurting out, and we as the arbitrator get to hear it. I'm always curious what it is, but you need to train them to stop when there's an objection. We also need to train the arbitrator. You understand that there's probably an age factor with us arbitrators. In fact, I'm just laughing. I was just laughing because when we talk about audio technology, one of us earlier in this panel talked about those ear things, those ear things. Yes, we need to be trained as well. You need to make sure the arbitrator is comfortable with it. And perhaps that practice session is something that is important. We need to know who's in the room, what's on the desk, no virtual backgrounds to hide. I know there was one very contentious case where the one side suggested that the witness, before they started, hold up their screen and then show everything that's in the room and show the desk so that they can see if there's something else going on. You may want to put it into the oath too, that they verify under oath that there's nobody else there, that they're not looking at something else, and they're not consulting whatever. And that can be part of also perhaps an agreement that if there is a glitch like that, to stop the gaming, that it's not going to be a grounds for having an attack on the ruling or on the on the award itself. I hadn't thought about this before, but it was pointed out to me in a different context that there may be HIPAA documents, HIPAA-sensitive documents, or perhaps just sensitive documents. If it's a high-profile case, if it involves a celebrity, maybe there's people that might be interested in finding out what's going on, doing a little snooping. The arbitrations rarely take one day. So what happens to those documents when we have the break overnight? Are they just left there? Is there any scrutiny paid to protecting HIPAA medical records of somebody? We want to make sure we protect the privacy. We plan on how the documents are going to be delivered to the recipient, to the remote witness, and also what happens when we're done with it. What happens when we're gone overnight? Do you want them returned? Do you want them destroyed? We want to protect some HIPAA issues. Plan B is the last thing I want to talk about. What happens when it all goes wrong? If your witness gets disconnected? Obviously, we need to be able to contact them. They need to be able to contact us if we may not even realize they can't see us anymore. There should be a dedicated emergency contact number. And perhaps at some point, the arbitrator, perhaps the parties may even need to terminate the format of remote if somebody's being disadvantaged, or that the integrity of the setting of the arbitration is compromised in some way because it's either being gamed or whatever. I can imagine, I haven't seen it, but I can imagine a situation where the witness is testifying, does really great on direct, and somehow the technology fails on cross. Oops, what do we do with that? What happens if audio fails? We can do backup stuff as long as there's planning. We can do it by phone for the audio with the visual available. If it swaps the other way around, perhaps they can appear on a laptop or tablet or something else while the audio still goes. Or maybe the whole thing collapses and we just go by phone. Perhaps there's an agreement ahead of time. We're not going to do this by phone because it's a small screen. You can't really see, the sound is not as good. But this is something that you need to talk about and figure out in advance. If it's a short delay, that's one thing. But if it's a long delay, who gets disadvantaged? That's something we need to think about. Who ends up paying the price for the fact that, we have two hours set aside for this witness. I've lost 45 minutes of it. Is that going to be on me? If the attorneys get along and we end up being able to extend, that's one thing. But sometimes the extension, as I indicated, creates this whole separate problem because it gets put over for a month or something like that. So lots of things that can go wrong, lots of things that do go wrong. The whole idea is planning for it. The whole idea is being prepared and for everybody to be flexible. But I think, again, one of the biggest things is having that big screen for the witness who's testifying, having it close to the arbitrator, and having a set time for when the witness testifies. So now we're kind of inviting each other to weigh in, because I'm sure there's.
I would like to weigh in. So, I made my comments in terms of why I prefer in person, but I want to make some comments in terms of doing an arbitration entirely over Zoom. And I had that experience early on in the pandemic. It was a case of a partnership that had, the partners had decided to go their separate ways, but they had a lot of accounting to do to each other. They were involved in a variety of real estate transactions, and each transaction had its own separate agreement. And the arbitration lasted several weeks entirely over Zoom, with essentially 4 witnesses, the 2 partners, and each partner had an accountant. And I will tell you that I was pleasantly surprised at how effective it was. And at the end, it was my job to go through the numbers and decide who owed what to whom. And it was quite involved. And it took me quite a while to go through all of those numbers. And I found myself still having some questions. Even while I'm writing the award, I've got questions. So I wrote it out the best that I could, but kind of set aside the areas where I still had a lot of issues, and contacted the lawyers and said, what I'd like to do is reconvene over Zoom and just have the accountants present to go through my numbers, because I wanted to make sure I got those numbers correct. And with the help of those 2 accountants, we were able to go back on for a full day, go through all the numbers. It aided me tremendously. And I was very comfortable at the end that I had a correct award in terms of who owed what money to the other party. So a shout out to a totally Zoom arbitration proceeding that went right. And it made me a proponent, at least in terms of how successful they can be.
Jerry, I want to comment on one thing that you've said and one thing that Jackie said as well. First of all, Jackie, you raised the issue of who's going to let the people in, et cetera. And I think one thing that the community probably knows and appreciates is that at ADR Services, every case has a dedicated Zoom coordinator. So there's always a staff member that's available should there be a problem. If you get dropped off the call or dropped off the Zoom, someone's always available to get you back in, which is a great help. And apropos of your point, Jerry, about the experts, a lot of times people will have taken an expert deposition and videotaped it, and they want to use the videotape at the arbitration, which is great, but sometimes we arbitrators have questions that we want to ask the expert. And so having the ability to have the videotape utilized and then have the expert appear for a very short period of time for some direct questioning via Zoom is really very helpful. So I think you could do, to use Jackie's term of hybrid, you could probably have a hybrid application of the video deposition. But remember that the one downside in my experience is that arbitrators and judges oftentimes have questions that they themselves would like to ask the expert. So having the expert available by Zoom obviates that problem. And perhaps the most important thing about Zoom experts are in practice, you have an expert in New York who's going to testify for 2 hours, and he or she has to fly out to Los Angeles on day one, spend the night in a hotel, hang around, testify for 2 hours, spend another night in a hotel, fly back to New York, as opposed to just simply being available in his or her office for those 2 hours of testimony. It's a tremendous time and money saver.
I know, Jerry, you said that when people Zoom, they tend to be a little less formal. I've also had feedback from people who do remote testimony. They're more comfortable in their own space, assuming that it's controlled. But sometimes they're more comfortable and they're more natural. And if there's a credibility issue or something, they feel like they can present a little bit better than if they're in a lawyer's office or something else. So there's an upside and a downside. You're right; they tend to be a little bit less formal. But for some witnesses, that's actually helpful.
Sometimes,
and of course, the arbitrator needs to control that. But
sometimes people ask me, how do you judge the credibility of a witness when he or she is on Zoom? And I'd be curious as to your thoughts. I've always maintained that, as judges, we honed our skill as judges in doing just that, because we've told jurors for years, you're the sole judges of the credibility of the witnesses. In arbitrations, we are. I haven't found it a problem. I don't know if either of you have.
I'd rather see them near me where I can watch their body language, because sometimes that can be very telling. It's not just about what they're saying, it's how they say it, how they position themselves. And of course, in the courtroom, I'm in this box now, so you can't see me right now, but they're right here, literally. I can look down at them and watch their every move. And that's what I would do while I conducted court trials, is watch that witness very carefully.
yeah, I kind of agree with Joe. We're so used to doing this that maybe there's something we missed, but maybe there's some games by it too, to have them be focused on just one camera. But yeah, you do miss a little bit. You miss you miss that shaken foot underneath, or the rattling the fingers or something else. You do miss some of that. That may be the wrong telltale signs, by the way. The science sometimes suggests that what we think is a sign of lying turns out to be just a nervous tick, or totally unrelated to the information that we're interpreting the wrong way. So it can go either way. I don't think there's a huge disadvantage to doing it, but there certainly is an advantage in the costs, especially if it's experts or someone that doesn't have to be evaluated in terms of credibility based on their demeanor.
I just want to revisit something I said earlier about recusing myself in a case. One of the responsibilities of judges that we all experienced when we were on the bench, which is different than being an arbitrator. You agree to be an arbitrator. In the canon of ethics for judges, we are instructed that we must take any case unless we're somehow disqualified, which is very different. We can pick and choose in this practice. And I did make my comment about recusing myself because I was very concerned that if I ruled either way, one of the parties would attack the judgment as having been inappropriate. So I want to remind the folks that judges are to take, and most arbitrators recognize that we should take those cases which come before us, which we feel competent to adjudicate.